name is Kovačić. I'm a judge. I work on a county court in Karlovac. I deal primarily with first instance courts, but cases, but also with second instance cases. Okay, thank you. And of course, a big part of my work is dealing with economic crimes, and in those cases, I found certain problems which I would like to share with you today. Let me start by saying that according to a relativist theory of criminalization, a law develops, or it should develop, at the same pace as society. But in Croatia, in some cases of criminal law, it is not so. As actually, it is lagging behind. And this kind of situation has been apparent for more than 20 years now. To explain this in more details, I will, two cases will be presented. First refers to the lack of existing norms, which in itself is a rarity in Croatian legal system, but it still can happen, as you will see. And the second case shows that regulation is adequate, but that there is a problem with its implementation. And that is, as we discussed yesterday, quite a big problem because it concerns confiscation of legal assets. And so while economic crime has obvious ability to change accordingly to new economical, political, social, technological, geographical development of situation, and it seems that changes cannot be stopped no matter what actions are taken. We must ask ourselves, is it because of a lack of political will, inadequately law regulations, or we must acknowledge that economic crime will always be a step of efficiency of the judiciary. Therefore, the obvious questions appear. Is it a matter of particular time we live in, or is it the incompetence of law enforcement authority or the lack of law regulation? Sometimes it seems that it is all of these things, as you will see later. Next questions are, why does it happen, and what should be done to prevent it from happening in the future? In the first case, the first accused person is the director of company A, but he is not the owner of company, that company A. The second accused is his wife and also the owner and the director of company B. The first person is accused of entering into business contracts to the detriment of company A and in favor of company B. The second person is also charged with entering into the same contract with, to the detriment of company A, but in favor of company B. Both are charged with the criminal offense of misuse of trust in business under Article 246 of Croatian Criminal Code. However, in order to commit this criminal offense, it is necessary to cause damage to the legal entity in which the accused is responsible person and for whose interest he or she is obligated to take care of. The company A is the legal person or entity in which the responsible person, that is the first accused, certainly caused damage. The company B is legal entity in which the responsible person, that is the second accused, has only obtained benefits, and the responsible person is not obligated to take care of the interests of other legal entities with which he or she is doing business with. The question might be raised whether the second accused has committed any other criminal offense, for instance, whether she participated in the commission of this crime as an instigator or helper. Such possibility in this case must be ruled out for the factual reasons. Since these are spouses who did not admit to committing a criminal offense, and since they both had an equal interest in obtaining benefits, it is not possible to say with certainty whether the second accused was the instigator. Furthermore, the actions they took were of the same intensity. Both signed a cooperation agreement. First accused made a payment for jobs that were not actually done, and the second accused issued an invoice for actions that did not perform, that she did not perform. Therefore, their role in committing the acts is equal, and they can only be co-perpetrators. However, it has been said, co-perpetration of second accused can be ruled out since she is not required to take care of the interest of the legal entity A. Given the state of things, we have to exclude the possibility that the second accused had committed another offense, such as some form of fraud. In order for someone to commit the criminal offense of fraud, it is necessary to mislead other person, which is certainly not the case here, since the second accused took action with prior agreement with the first accused. The conduct of the second accused does not constitute a feature of any other criminal offense under the Criminal Code of the Republic of Croatia. So it can only be concluded that existing legal solutions do not cover all forms of economic crimes. Looking back in the past, we must admit that economic crime in its manifestation is not constant in its form, but rather determined by changes in the outside world. Back in the past, when the trade regulations were abolished in Europe in mid-19th century, and there has been a transition from state-regulated trade to free trade, first economic crimes committed by joint stock companies appeared. On these crimes, the state did not react as promptly as it would today. The main reason for the lack of legal reaction of the state was that until that period, state prosecuted only criminals that have committed a crime against public interest, such as murder, for instance, but these crimes that were not in the public interest had to be prosecuted by victims themselves. In such investment frauds, many of the investors were not able to prosecute because they could not bear the expenses of the trial since they did not have enough assets. Therefore, in the middle of that Victorian time in Great Britain, there was a lot of negative public campaign demanding justice. And so about 150 years after the famous South Sea bubble scandal, Office of the Public Prosecutor was founded to ensure that cases relating public interest would be prosecuted regardless of the will of the injured party. Here we can see that economic crime was already in its first forms a step ahead of legislation. In terms of permanence of crimes, we can say that we know some crimes that have been present since time immemorial, such as theft or murder. Then there are offenses that are related to historical moments, like, say, punishment for adultery. Also, there are crimes that were not previously punishable. One such example is domestic violence. Furthermore, we can say that some crimes do not change their form over time. The act of committing is the same. The protective object is the same. The aforementioned crime of theft or murder has not changed significantly throughout history. This unchangeability is particularly marked at the criminalization of the offenses of domestic violence, which is not likely to be changed in some future period of time. Some forms of economic crime have also been known throughout history. For example, fraud committed by a trader today would be qualified as fraud in business operations. Fraud related to counterfeiting value signs has also been known throughout history. Various forms of tax fraud are also known. However, some forms of economic crime did not exist previously. For example, in the past, the king of a state was sovereign and could dispose of funds accordingly to his own wishes, despite of the fact that these funds were collected from taxes paid by taxpayers. Today, in democratic countries, this would not be possible because the state government is expected to handle state finances transparently under the threat of criminal prosecution in the case of malversation. In the past, as well as now, it has been problematic to classify certain behaviors as economic crimes. Sutherland mentions the case of United States Rubber Company, which was organized as merger of firms manufacturing rubber footwear and has by 1900 controlled 80% of rubber footwear business. In 1902, the Hood Rubber Company sued the US Rubber Company under the antitrust law because US Rubber Company made an agreement with all of the firms which made the lasts for the rubber footwear that they would not sell lasts to the firms other than US Rubber Company. The Hood Rubber Company tried in vain to purchase the lasts from each of the manufacturers. Although this declaration was filed in 1902, no court action appeared until 1916, when the demurs by the US Rubber Company were overruled. No further action is reported and settlement was probably made out of court. It's one of the first cases of its kind from the United States. We can see that it was obviously not a simple case for the court, since it took the court 14 years to reject the motions, and even then the dispute was obviously resolved by out-of-court settlement, although the antitrust law was brought in 1890. So the conclusion is, although the undoubted criminal law regarding economic crime has undergone significant changes since then, we can still enumerate cases in which legal regulations do not provide an adequate response to, that would cover all forms of economic crime that we know today. The second case involved the illegal sale of apartments between legal entity and natural person. The legal entity bought the apartment and renovated it for its own expense. After some time, the apartment was sold by legal entity to a person at a value far less than amount spent. The director of the legal entity was related to the natural person to whom the apartment was sold. So the prosecution claimed that it was an illegal act to the detriment of the legal entity. The value of the renovation of the apartment was determined, but it was not stated which work were performed. The period of committing this crime lasted for 4 years. After filing a criminal charge under the court hearing stage, the apartment was additionally renovated in period of several years. In fact, the court could not determine which part of the apartments were renovated. The court could not determine whether these works were performed either before the criminal charge was filed or after. So it is not a question of committing a criminal offense, which is undoubtable, but the amount of illegally obtained assets. Due to the passage of time and the actual situation, it was no longer possible to determine the amount of this illegal asset. In this case, the norm is clear and applicable. However, not all necessary actions have been taken to determine the amount of benefit obtained. Consequently, confiscation of illegal asset becomes impossible. From this case, the conclusion follows that only an appropriate legal regulation is not enough. Appropriate action by the competent institutions is also required. It includes all the necessary measures to determine the legal assets obtained and to confiscate them in time as well. So this was actually a rather simple case regarding to the obtained assets, but the actions were not taken on time. The assets should have been frozen in the beginning of the procedure, which was not done, and after that it became quite impossible. Thank you.
Thank you very much. So what do you say? What do you say is the most important for you that makes you able to confiscate the assets once the perpetrator has been identified?
Well, as we have heard yesterday from our colleague Faisfeld, it is quite a difficult job. It is not a job that can be done quickly. It has to be prepared. It usually involves a lot of people from police and so on. So that's the most important thing, because the assets, when time passes, are usually gone. So the reaction must be prompt. By the time that person is arrested, those assets should be somehow frozen or confiscated. After that, if it's not done on time, assets are usually sold or transferred to the other person. And the other thing that it is important, as we heard yesterday, this kind of obtaining, this kind of confiscating illegal assets should be obligatory, not this is not, that should not be an option, but it should be done always whenever the crime that involves illegal assets is in question.
Mm-hmm. We have 3 more questions here from Kovačić. What is the most successful method in suppressing economic crimes? Then we have from Michaela, what are the key shortcomings in Croatian judiciary in the cases that you have encountered? They allow economic crimes to proceed smoothly. And one from Zoran regarding the criminal act of breach of trust. How often does it occur in your practice? Are there any problems in proving that you have noticed as a judge? More or less, their questions are related to the same issue. Can you please address them? First one, what is the most successful method in suppressing economic crimes?
Well, the most sufficient action would be, I think, that the one that we are not doing, that the one that we are missing to perform, because all of these economic crimes are done with only one reason. The reason is financial reason. So if a person commits economic crime and then gets a sentence, it is only a partially response from judiciary in whole. The first and the most important act is to confiscate the assets, and that would prevent people from doing this type of things. Because, for instance, yesterday we heard an example from a German arm factory. So from this example, we can see that this is not organization, this is not a legal entity that was started with the aim to only perform criminal acts. This is something that has happened along the way. So, so as well as other people who are involved in business operations, they are not the kind of criminals that will do this kind of things repeatedly. But it's a kind of performing business operations and obtaining illegal assets along the way with it. So the only way to prevent it in the future is to confiscate the assets, of course, along with the punishments that need to be appropriate.
Then from Michaela, what are the key shortcomings in Croatian judiciary? Yeah, that allow economic crime to proceed smoothly.
I think that well, as you all know, it's not some kind of a secret. The cases in Croatian courts and the procedures before they get to the courts, it takes quite a long of time, because that's definitely not a good thing. Procedures should be more quickly finished, and that is one of the aspects. And the other is, as I have mentioned before.
Then we have also Anya at the end. Actually, Anya's question, but we won't miss Zoran's. Anya's question actually reflects your first slide, but let's go first to Zoran. Regarding the criminal act of breach of trust, how often does it occur in your practice? And are there any problems in proving that you have noticed as a judge?
Breach of trust?
Problemi u dokazivanju. I koliko puno, to je ovaj 246.
Regarding to the breach of trust, well, it all depends how well the case is prepared when it comes to court. But I mean, it's always like that. That's not that doesn't differ this kind of cases from other type of cases. But I can say that it all more or less refers to the documentation that is in the file, but it also refers to the period of the time between the time when crime was committed and the time of the trial. But actually, if we have all the documentation, that's no problem. Of course, documentation is only one part of the job. The other part are witnesses. As we have heard today, witnesses have often very good reasons not to repeat what they have previously stated, and that could become a problem. But in major part of this economic crime, expert witnesses are quite important. They can do a lot of job.
Okay, and coming to Anya, when you mentioned relativism in the beginning, right, of your presentation, is this a reflection of your own hope to see ethically prescriptive pressure?
Well, I think that economic crime changes. It is not constant, as I have explained, but I think that the changes are influenced by the economical, political, or other factors that I have mentioned. So it can be different in different parts of the world. It can be different depending on technological development of the state or or organization or a legal entity or so.
But do you think that it should reflect ethical principles or?
Definitely, yes. Ethical principles are, of course, very important in all this kind of illegal behavior, because social development is very important, and it affects to committing this kind of crimes. Because if the ethics are on the high level, then of course if the social development is on the high level, if people's conscience is on the high level, that I think that that should lower this kind of cases.